Jan?
Morning, Chairperson. Yes.
Hi.
Right.
Hi.
Thank you, Dalen.
Right. Thank you. I think we have a quorum now. It is the 4th of May, 2021. It's the Standing Committee on Local Government. Our agenda for today is that we will have a briefing from the Department of Local Government on their written submission on the Local Government Municipal Systems Amendment Bill B28 of 2019, and then the committee will then consider um, their written comments. Um, Thereafter, we will consider and adopt draft minutes of this committee, and we will then lastly formulate possible resolutions. Now, allow me as chairperson to welcome all those who are attendants at the meeting, and I will specifically mention certain individuals later on, but may I call on the members who are present to introduce themselves, please. I'm Derek America, chairperson of the committee.
Andrikus van der Westhuizen, member of the committee.
Matlodi Maseko, member of the committee.
Any other members?
Dan Smith, member of the committee.
Okay, welcome honourable members to the meeting. May I ask Johan, did we receive any apologies?
Chairperson, no, I've received no apologies. We may proceed.
Thank you so much. The members of the committee and many of us who are present are by now fully conversant and au fait with the rules of engagement regarding virtual meetings, but I will simply just point out one specific matter, and that is our request for ease and of reception from certain members in certain different locations, that if we could disable our video function and only those who are speaking to the agenda may switch on their video cameras for ease of identification if they wish so. Secondly, we have on standby Ms. Candice Morris from the ICT department, who will assist any member who may experience technical difficulties during the course of our meeting. So, colleagues, we have the Department of Local Government under leadership of who leads their delegation, Mr. Kamal Makan, who is the Director of Municipal Governance, as well as the Deputy Director, Ms. Mgledle. And we also have Ms. Claire Williams, State Law Advisor from the Department of the Premier on the platform, as well as the Provincial Government's Legal Advisor, Advocate Ramia Maasdorp. Then we have officials from the National Department of Local Government and Traditional Affairs under the leadership of Mr. Jackie Mahepa. And when respective officials may speak to the agenda or called upon to make an input onto an item that's on the agenda, they will then be introduced by their respective delegation leader. So with that, colleagues, I want to extend our sincerest welcome to all the officials who have made themselves available to be present at our meeting. Any questions or any comments any member would like to make at this stage before we proceed to the first point on the agenda? Johan?
Chairperson, yes, my apology. I just need to, I think I need to put it on record. I did receive an apology from the head of the department, Mr. Graham Paulser, but he did prevail some of his senior officials to take us through the amendments, but his office did submit an apology for today.
So noted. Thank you, Johan. Colleagues, may I just briefly contextualize the purpose of this particular meeting. You will recall that on the 31st of March, we had a briefing from the National Department of COCTA in relation to the amendments to the Municipal Structures Act and where it emanated from, and all the incorrect tagging and how it landed up here with us today. And also we were taken through a presentation that gave us contextualized the various amendments. At that meeting, the committee then decided to put the amended version of the bill out for public participation, and don't know if it was it was a welcome amendment, but the feedback we received from the public and the various municipalities and ways were very minimal, and those that did comment on the bill express their support for the amendments. But we have a presentation from the department that we will speak to, and it is not very substantive inputs, really of a technical nature, but we will let the department speak for itself, and then thereafter I will give the legal sort of advisors on the platform with us just to give us their sort of perspective on the amendments. So without much further ado, I call upon the Mr. McCann, the department's director, that will take us through their submissions. I don't know, Johan, if you're going to flight their presentation, or they're going to do it themselves, and then we can take it from there. Thank you.
Morning, Chair, and morning, honourable members, as well as colleagues on the platform. Chair, if I may ask Johan if he could flight it, and then I can maybe just direct him on the slide movement thereafter.
Thank you, Mr. McCann.
Will do, Chairperson. Is it visible, Chairperson?
Yeah, it's visible to me. I don't know if it's visible to the other members.
Chair, sorry, if I may intervene, we provided a presentation. I'm not too sure if Johan has got that presentation, which was forwarded to him. If I could ask that presentation be displayed, please.
Chairperson, I did not, but let me just go and have a look. Chairperson, that one, is it visible?
Yes, to me.
Kamal, is that the right one, eh?
Yes, thank you.
Sorry about that.
Thank you, Chair. Chair, if I may comments, just the introduction, and Johan, if you could take us through to the first slide, the background to the Municipal Systems Amendment Bill. Chair, as you probably know, and as the other members do know as well, as a result of the Constitutional Court's declaration of invalidity of the Amendment Act 7 of 2011, in the case of the Sambu versus the Minister of Cooperative Governance, the current bill had to be reintroduced into Parliament for the process of adoption again, as those key provisions relating to the appointments of senior managers had been declared unconstitutional, which was in 2019, after the period of the 24 months, which was provided by the Constitutional Court in the amendment being rectified. Thank you, Johan. Chair, just a briefing and key inputs onto the objects of the bill. It reintroduces the professionalization of the public administration in municipalities. The bill has pertinent provisions related to the appointment of senior managers in the municipal context. It reaffirms the recruitment and selection process, ratifies the appointment of qualified, skilled, and competent senior managers in municipalities. It also regulates the appointment of acting appointees. When I refer to acting appointees, I'm talking to the provisions pertaining, which are contained in section 54A and 56, which is the municipal managers and the managers directly accountable to municipal managers. In the event that there are vacancies, there are provisions that have been introduced by the bill. The bill also provides for the secondment of a municipal manager, which was previously in the Act 7 of 2011. I think this is a key provision. Municipalities struggle to fill vacancies, hence the empowering provision of enabling the MEC as well as the minister to second a municipal manager to a municipality upon the request of the municipal council. Um, the the bill also nullifies appointments of incumbents who do not meet the minimum prescribed requirements. Um, just this provision that is contained in the bill just provides more credibility as well as a foundational basis for the enforcement of the act. And also to invalidate any appointments which are made contrary to the act. Um, the the advertising process, which is made reference to in the bill, is just providing a competitive process that the adverts are published nationally, so that there's a pool of suitable applicants that can apply for the post, and then providing the municipality an opportunity to select a suitable person in a Section 56 or Section 54A position. Um, the the provision that is contained in the bill also empowers the minister and the MEC to take appropriate steps against invalid appointments, so that when it comes to local standi, when we go to court, the MEC has got the power in terms of the provision that is contained in Section 54A 8, as well as Section 56 of the bill. The the other object of the bill, which it introduces, is the waiver of prescribed requirements related to skills, expertise, competence, and qualifications, as you've noted and the members have noted. The provisions that are introduced in the bill requires the minimum required skills and expertise, as well as competencies and qualifications of senior managers. However, in most cases, or in a lot of instances, municipalities find it difficult, especially our isolated rural municipalities, find it difficult to employ candidates that meet those requirements. Hence, that enabling provision of a waiver. Thank you, Jan. Chair, just a general comment. We've picked up on the in the formatting and the editing of and the language of the bill. We picked up quite a bit of errors which are not in compliance with the Commonwealth Conventions on Legislative Drafting. We've highlighted those errors as well as problematical drafting practices, which are contained in the current form of the bill, and which is contained in detail in our comments that we've submitted and which we've also made available to the Standing Committee. Thank you, Chair. Jan, thank you. Chair, just the highlighting the one aspect, the definition of political office bearer. We've indicated that means the definition of the current definition of political office bearer as contained in the prevailing act should also include whips. Whips have been incorporated in the Municipal Structures Amendment Bill as office bearers elected in terms of Schedule 3 of the Structures Act. However, the current form of the definition in the Municipal Systems Act does not include whips. Hence, we've indicated and proposed that, the definition of political office bearer includes a whip as well, in addition to the other office bearers as contained in the prevailing definition. Secondment, we strongly suggest that that a definition of secondment be provided in the bill, so that there is clarity regarding applicable conditions, as well as the criteria, as well as the requirements that are associated with a secondment or a seconded person to a municipality. At the moment, the bill does not include a definition of secondment. However, reference is made thereto in Section 54A, 6A, and B of the bill. Chair, we've also highlighted the fact that The proposed Section 54A9 obligates the minister, the MEC, to take appropriate action, whereas the national minister, there isn't an obligation. However, there's just a discretionary um, provision that he can take action. We suggest and also affirm that there should be a provision that also obligates the minister to take the action if an MEC fails to take an action.
Mm.
Thank you, Jan. Just an incorrect reference to definition or reference to the term senior manager in Section 54A 10. The Section 54A is primarily dealing with the appointment of municipal managers. Hence, we're indicating that, that that provision of senior manager or that term of senior manager should be changed so that it's aligned with the remainder provisions of the bill. There's also an incorrect reference in section 54.8.10. It incorrectly makes reference to subsection 7b, whereas it should make reference to subsection 8, which pertains to the failure of an MEC to take action within the 14 days, as contained in section 54.8, 54A8. Thank you. With reference to section 56.2, we've picked up again that there's been a absence of reference to municipal to managers directly accountable to municipal managers. At the moment, the requirement pertaining to prescribed skills, expertise, competencies, or qualifications has a cross-reference which only makes reference to acting managers directly accountable to municipal managers, whereas it should be equally applicable to managers that are also directly accountable to MMs. Thank you. Check clause 54A6, the amendment there, and clause 4, which provides for the substituting of municipality with municipal council. We're indicating in our comment is that it's become superfluous to the extent that, the bill or the provisions of section 54A and 56 have already been amended and does cater and does make reference to municipal council. Hence, that provision of clause 4 is redundant. Thank you. Chair, with regard to section or the amendments to section 120 of the bill, we've indicated that there are certain provisions where the minister or the national minister is also obliged to prescribe regulations. For example, there's an omission in relation to section 57A, which relates to the prohibitory periods for when senior managers cannot be appointed in municipalities. And we've indicated and we've also highlighted that in our comments that the just take cognizance of the fact that that there are certain provisions that enable the minister to prescribe regulations. One of those being section 57A. Thank you. Chair, we've also just wanted to highlight that at the moment, Section 82 prevails of the Structures Act, which deals with the appointment of a municipal manager. And we're highlighting the fact and raising the concern that Section 82 of the Structures Act also be repealed, as if the two prevail, there will be a conflicting provisions between the two acts, being Section 82 correlated to Section 54A, which deals with the appointment of municipal managers as well. Hence, we just highlighting the concern that Section 82 of the Structures Act is ensured to be repealed as well. Thank you, Johan. Chair, thank you. And I've come to the conclusion. We just wanted to highlight the fact that we didn't want to hinder the legislative process. This bill is urgently required. As in the absence of the Amendment Act 7 of 2011, it's caused a major void in the legislative framework, especially the uncertainty in the enforcement of the prescribed recruitment and appointment processes, the empowerment of the MEC and the Minister to take legal action, the provision that introduces or allows waivers where incumbents don't have the required skills and competencies, secondments, and then also the enforceability of invalidity of appointments when they are in contravention of the Act. And hence we support the fact that the bill should be adopted as soon as possible, and in order to fill that vacuum or that gap that has been caused by the fact that Amendment Act 7 of 2011 had been declared invalid. Thank you, Chair.
Thank you, Mr. Kamal, for that briefing. I'm going to ask if any of our legal advisors would like to make a comment or anything to that regard in relation to not the presentation, but to the amendment itself. I see Ms. Williams.
Good morning, Chairperson and members. Yes, I just want to confirm that the Department of the Premier worked with the Department on Local Government on these comments. So I do not have anything else to add. All our comments have already been discussed with you. Thank you very much.
Thank you so much, Ms. Williams. Advocate Maasdorp, do you have any comments you'd like to make?
Yes, Chairperson, thank you very much, and good morning to the colleagues. Let me just call up my own notes here, Chairperson, if you don't mind.
It's fine with me.
Yes, Chairperson, thank you very much. I have noted the input made by colleague Makan, and some of the points that he has raised have been observed by myself in particular, and I think this is maybe a point that I just need to premise on the following. If one appreciates the memorandum on the objects of the bill, then a pervasive thread of this bill is the need to professionalize the capacity of local government. In fact, it's also a need to ensure prudent governance at local level. We are very, as citizens of the country, we are very aware of the lapses in governance that happen at local level. So one can then appreciate how this piece of legislation will be inserted within the regime of legislation that provides for the management, the auditing, ethics, if you like, of local level capacity. So one would then look throughout the Act, if that is what is the objectives of the Act, one would then look for instances throughout the Act that not only complies with that, but also ensures it. Colleague Kamal Makan has just raised the one, which I also just want to highlight, and that is in section 54A. We notice in section 54A(8) that
if a person is appointed as municipal manager in contravention of the section, the MEC must take steps to enforce compliance. As Makan has noted, for some reason, there's an obligation on the MEC, but it allows for a discretion on the part of the minister. Now we know, and this is just me creating premise and context of what I'm saying, we know the highly politicized dynamics that prevail at local level. So one would then want to see a consistency, a common consistency that rests with the MEC as political office bearer to ensure steps to be taken for compliance, for the same to be visited upon the national political office bearer to take steps equally. But that's just the one observation where the MEC is obliged, but the minister has a discretion. If one reads the first few lines of 54A8, it says, if a person is appointed as municipal manager in contravention of this section, the MEC must take steps. The question in addition which I have is, someone is appointed in contravention of the section. In other words, in contravention of the law. My question is, who takes responsibility? Who is accountable in terms of this act for that contravention, for appointing someone in contravention of the law? We know that the minister after the fact and the MEC after the fact may take intervention steps, but a compliance has already been violated. Who takes accountability legally for that? That's the one question I have as well. And there are other examples where there's a failure to comply, but steps are being proposed to ensure the compliance, but the act somehow just falls short of keeping account, holding accountable those that in the first place allowed for this non-compliance. In fact, it says in that very 54A8 that the MEC may even go to the High Court for a declaratory order on the validity of the appointment. But it's silent on steps to be taken against those who made the appointment. Undoing the appointment is one issue. The initial contravention, somehow the act, this bill, however, falls short of raising that. That's the first point, Chair. Also, I notice in clause 6, if colleagues will just bear with me, it speaks of dismissed employees or dismissed staff and record of disciplinary proceedings. Any staff member dismissed for misconduct may only be re-employed after a certain period. And further, it also speaks to, if one looks at clause 6.9, it speaks to the minister must maintain a record of all staff members that have been dismissed for misconduct or resigned prior to the finalization of their disciplinary proceedings. Now, let me premise the following statement on this context. I'm also a citizen of this province and of this country, and often we see that staff members at local level or even at any level escape, circumvent, flee from disciplinary proceedings by resigning before that is finalized. Now, it says the minister must maintain a record of that. If one looks at the objects of this bill, it speaks to prudence in governance, the lack of capacity, the need for professionalization of that sphere, etc. And when we talk governance, we're talking the management of public funds. One would have then wanted to see an obligation visited upon a municipal council to still pursue staff who resign before disciplinary proceedings for the recovery of any public funds which may be lost due to their misconduct. So one would have wanted to see new offenses, statutory offenses being created, and new obligations visited on a municipal council to pursue, to still, notwithstanding the resignation, to still pursue on in the civil courts the recovery of public funds. I notice in clause 10, it says staff members prohibited from holding office, political office. A staff member may not hold political office in a political party, whether permanent, temporary, or acting. And then it says, a person who has been appointed as a staff member before subsection 1 takes effect must comply with that section within 1 year of the commencement. That is fairly straightforward. But if one looks at why is there a need for this? Why is there a need for a staff member, for a provision that a staff member should not hold political office while being a staff member? Again, it is for preventing conflicts of interest. It is to ensure the interests of the institution, the municipality and the municipal council are paramount and are not maybe subservient to a staff member's other potential public and private interests. So we say, and this seems to be the very loudly proclaimed objectives of this memorandum of this bill, if you talk prudence and governance and accountability and transparency, we say a staff member may not hold political office if he is appointed. But for some reason, we say, you know what, although you may not hold political office at the inception of this section, you can still hold that office for 1 year after the inception of the section. That is mind-boggling. Why for a continuous period of 12 months, this act, proclaiming its transparency, its governance objectives, etc., still tolerates someone who is conflicted when that is proclaimed to be one of the objectives we want to prevent. We still tolerate an official to be in a conflicted position for another 1 year after the inception. That boggles my mind. It must be removed. In any case, there's no basis where the 1 year period comes from. It is arbitrary. It doesn't speak to any rational basis. Also, I just need to gather my following notes, Chair.
Good in May.
Clause 14. Clause 14. It's a new insertion. It says that a councillor may not vote in favor of or agree to a resolution which is before the council or committee, which conflicts with any legislation applicable to local government. So, a councillor may not vote in favor of anything that is contra the law. Now, I'm not sure how this will be monitored or enforced.
Advocate Master, could you just hold your fire there for a moment? Honourable Smith, I see your raised hand.
Chairperson.
Yes, please, I recognize you.
No, Chair, I just wanted to ask, I'm hearing more dogs at the back of the advocate. Sound and noise is a bit disturbing. I couldn't hear his last part. So I just wanted to address that noise, please. Chair.
It's noted. Thank you, Honourable Smith. Honourable Master, you may continue.
Thank you. In fact, I'm pleased that Member Smith raised that, because the issue with my neighbor's dogs is quite a community issue. The dogs are in therapy at the moment because of their constant barking. But thanks for that. It also bothered me. Let me just put the following again. I'll just, as far as the councillor may not vote in favor of a resolution, which is in conflict with any legislation. My question is, there's silence in the bill on how that will be monitored or enforced. Because this may be an individual councillor who votes, and we don't know whether this is in an open vote or in a secret vote, but there's just silence on how that will be enforced, where a councillor votes against the law. And what consequence there may be, should it be that the councillor in fact does do that. There isn't a new statutory offence, for example, being created, that a councillor who, after an investigation, has been found to have voted in contravention of any legislation applicable to government, shall have committed an offence which is punishable by a fine or both imprisonment and a fine. There isn't such a statutory offence created if there isn't this compliance. What I said earlier, Chair, is on a few occasions in this bill, there's instances where the MEC must intervene in the absence of compliance, but there's silence on consequence for the initial compliance. This is one instance as well. Also, like I said, where someone resigns before disciplinary, there isn't provision here for follow-through, that notwithstanding a staff member's resignation, the council is obliged to still pursue the person who has resigned for the recovery of public funds where it may be lost. I just detect a lack of follow-through. And the initial point I made, again, follow-through, that the minister has a discretion, but the MEC is obliged. Why isn't there that obligation visited upon the minister as well? Again, the highly politicized sphere that we are confronted with at local level, there's no consequence, there's no follow-through by the minister. If there's obligation on the minister as well, one can be assured, hopefully, of a consequential outcome of a follow-through. Chair, some of the issues that my colleague Makan raised, I have also identified. I won't repeat it here now, just for the interest of time. So I will just rest with that for now, Chair.
Thank you, Advocate Master. I think you've introduced a number of necessary comments that needs to be considered by this committee in terms of us having to formulate a mandate for representative in the NCOP. I will recognize Mr. Jackie Mayepa, if he's on the platform still, if he has any comments to make from the National Department of Cooperative Governance and Traditional Affairs. Mr. Mayepa, are you?
Good morning, Honorable Chairperson, Honorable
Morning,
members, Honorable Councillors, colleagues. We have noted the comments made by the Western Cape Provincial Department of Local Government. I must say that the majority of the inputs are not, necessarily substantive, but are more editorial, in nature. We note them, we appreciate them, and I guess that's the work that needs to be looked into by the legal colleagues, as we're moving forward to finalize this bill. These are the inputs that can be submitted back to the NCOP. We have taken note of them. As regard to the issues raised around the definition of the political office bearer, I am not sure, whether this is a consequential amendment or what, but it looks like we're raising it, in relation to the definition that is provided for in the bill, which focuses on holding of political office. I just wanted to get some understanding, from Mr. Makan, as to whether we're just introducing this on the basis that there's a separate bill, structures, municipal structures amendment bill that is running, which introduces the role of a whip, or are we not confusing it with the political office, because those are two different concepts. Coming to the issues that have been raised by Advocate Masdorp, I must indicate, Honorable Chairperson, that indeed, the inputs look progressive. Maybe starting with the issue around the role of the MEC vis-a-vis the minister in relation to an appointment that has been made irregularly. The assumption, during the drafting process was that the MEC, becomes the first port of call to act on any contravention of the provisions of the Act once it has been approved. And the minister can only act in the event that the minister can only act in the event that the MEC fails to do so. So in this particular instance, the understanding was that it is not a must for the minister. It's dependent on the MEC carrying his or her carrying out, his or her executive authority as provided for in the Act. Failure of which then the minister, may intervene. That was the context, within which this was brought up. Why we're using the may and the must. But I must indicate, Honorable Chair, that as you are aware, the bill is currently before Parliament. If the provincial legislature is of the view that the point raised by Advocate is an important one that needs to be brought into, to give the minister and the MEC equal powers. it is incumbent upon the legislature to make that determination and make the submission back to the NCOP. Regarding the 3-4 issues that were raised by advocate about the bill being silent on first, in relation to an appointment that was concluded in contravention of the provisions of the bill or the act once enacted, especially in relation to the appointment of municipal managers and managers reporting to them, the introduction of clause 14 on the voting rights of municipal of councillors was intended to address that. Unless we are getting an impression that that particular provision we hold councillors accountable, for voting in meetings, contrary to the prescripts. The issue on the resignation, we noted, Honorable Chair, as I've indicated, is one of the progressive, inputs that I thought it looks like it's worth, taking forward, because indeed there's no express provision in the bill, to deal with that, except that there was just an assumption that, some of these processes will still be carried out, because if we were to look into disciplinary regulations for municipal managers and managers report directly accountable to municipal managers, they do provide for the municipal council to still proceed with the disciplinary proceedings, and that, I guess, is not limited to the administrative process, but even criminally, in the event where municipal managers or managers directly reporting to municipal who have resigned to avert sanction leave the municipality for any reason, that the municipality could still follow up, to ensure that they recover any monies that have been where municipalities have been defrauded by such individuals. The issue around the 12 months grace period, for municipal staff holding political office, I must indicate that in the original bill 2010, which was approved by Parliament and assented to by the President on the 5th of July 2011, the original caption was that no municipal manager, no a manager directly accountable to the municipal manager shall hold political office in a political party as defined. As defined in the bill. Whereafter we revived this bill in Parliament, following the invalidation, the Portfolio Committee on Cooperative Governance suggested that, these individuals should be given, the individuals who are holding political office must be given some period, within which to relinquish, resign from one of their active positions. And the argument, the context provided by advocate, I must indicate, it's again very progressive, because we're saying, should we even leave it for a day, a week, because a lot can happen in the process of that. But I'm saying it is not our original draft. This is an amendment that was introduced by the Portfolio Committee of the National Assembly. And again, if the legislature is of the provincial legislature of the view that this should be addressed out, suggest that we have it, as one of the issues that are put in the negotiating mandate of the bill going back, to the NCOP so that it can be addressed. The clause dealing with the record of dismissed staff. Okay, I think it's the one that I've just dealt with now. The last one will be on the monitoring of the voting in meetings. And any that there's a missing action as to what will be the consequence of that of voting against. And as I've just indicated, the assumption was that clause 14, which amends item 2A, item 2 of the schedule for the code of conduct for councillors was meant to address that. And if there is any contribution or proposal, again, it's up to the provincial legislature to make that determination. But generally, I must say all progressive inputs that have been made. Honorable Chairperson, thank you.
Thank you. Thank you so much, Mr. Mayepa. Recognize Advocate Maasdorp. Advocate Maasdorp.
Thank you, Chairperson. Maybe just following it, I thank Mr. Mayepa for his comments and his response to the comments. I did indicate earlier in agreeing with colleague McCann regarding the discretion which is given to the minister as opposed to the obligation to the MEC. That is the second leg, if you like, of that provision, 54A9, where 54A9 reads, when MEC for local government fails to take appropriate steps referred to in subsection 8, the minister may take the steps. Now, we've dealt with that part, the second leg. However, against the same background of my earlier comments, namely the premise on which this bill purports to be predicated, one of governance, one of prudent management, qualifications, professionalization, all of that. The first leg of that sub-9 reads, when MEC for local government fails to take appropriate steps referred to in subsection 8. Now, there are two issues that pop up there. The first is that there's no indication what accountability there is for the MEC when he or she fails to take the steps. It just says that the MEC must do certain things within 14 days of receiving information about an appointment. And in the very next section, in fact, it even says the MEC may even go to court to get a declaratory order within a certain period. The very next section, subsection that says, when MEC fails to do that, the minister may take certain steps. And then again it says, if the MEC for local government fails to respond to the appointment process, or the minister fails to respond as contemplated, the appointment will be deemed to be in compliance. My question is, again, the silence by the bill, or in the bill, of any consequence for the MEC who fails to take steps as he or she is obliged to do. If we speak consequence management, if we speak prudence and accountability, then surely an MEC equally must be held accountable for failure to take steps as the law provides. But then just the second point on that is we know the dynamic between national and MEC and local government. There's a very healthy tension there. And we also are very mindful of the need not to encroach on the various spheres of government. Each is sovereign and each must be given the space legally and otherwise to do their jobs as is provided. We are independent and autonomous entities. Municipalities, municipal councils are independent. So one should guard against having an instance where an MEC just steps in or where a minister just steps in when it comes to another sphere of government. So one doesn't lightly want to legislate where, for an instance, where a minister must just encroach and pierce the veil of another level of government. What I would have liked to see, therefore, Chair, in a provision like sub 9, where it says, when MEC for local government fails to take appropriate steps, the minister may take steps contemplated in that subsection. What I would have liked to see is a provision along the following lines, where an MEC fails to take appropriate steps, the minister must request reasons from the MEC for his or her failure, which reasons must be provided within X number of days. If the MEC fails to provide those reasons, the minister may take steps against the MEC. If the MEC fails to provide reasons, then and only then the minister must take steps to ensure compliance with certain provisions, so that you respect the role of the MEC, you hold the MEC accountable, and in the absence of that accountability, only then the minister must step in. You give then also, you empower the minister also to ensure that. So I'm just saying that even in sub 9, just in those two lines, there's about 3 or 4 provisions I would have liked to see built in there to comply with the very objectives that the bill seeks to achieve, which is prudence, financial management, governance, etc. Thank you, Chairperson.
Thank you, Advocate Master, for that further clarification. I think it is quite appropriate in my view, but again, I'm not the only one that's going to express myself in this regard. So, colleagues, that brings us to the end of the various inputs. May I also indicate that we have also received an input from the George Mossel Bay municipality that was circulated to members, and that input broadly speaks to its support for these amendments, and it's also sort of touch on one of the matters that was raised already. So those are the long and short of the inputs that we received. I'm going to open the floor to members for questions of clarity or comments. I welcome Honorable Maran to the meeting. He joined us a while ago, but I've just never had an opportunity to welcome him present. So, colleagues, the floor is yours. I see Honorable van der Westhuizen has raised his hand. So I see Honorable Moran, and I will proceed in that order for now. Honourable van der Westhuizen, the floor is yours.
Yes, thank you, Chairperson. And thank you to the officials that are really supporting us in this process. And I think the word was used substantial also by the official from National. And some of these proposals are, I think, not of any political nature. They're technical, they speak to punctuation, etc. And I think we need to distinguish between those two. But before we decide on the process going forward, Chair, I would appreciate it if we could just get an indication of the timelines, because I know in the past that some of the pieces of legislation referred to us via the NCOP, we've been put under very strict timelines, and I wouldn't like us as a province to miss any of the deadlines set to us, whether they are, very tight or not. I would like our input and the hard work that's been done in the Western Cape not to go to waste. So perhaps if our procedural officer or perhaps the representatives of National could just help us, because I think, unfortunately, time determines, in this case, perhaps strategy. Thank you.
Thank you, Honourable van der Westhuizen. Honourable Moran. Honourable Moran, I think you're on mute.
Chairperson, mornings.
Please, morning. Please proceed.
No, Chair. I actually got nothing to say so far, but I just wanted to say that I got to leave the meeting now because I have an appointment with the Koi Korana. They are already here, Chair, and I just want your blessings for me to leave this meeting. Kumo Denver is here. He's the main member of this committee, so he will be in this meeting. Thanks.
Thank you, sir. You may leave. Thank you.
Thanks, Chair.
Colleagues, any other any comments? Johan, can you? There was a question raised for Honourable van der Westhuizen in terms of timelines. Could you simply just give us an idea as to by when needs a final provincial mandate to be sort of formulated?
Chairperson, yes. In terms of the NCOP program, our negotiating mandate needs to be submitted by the 11th of May. And our final mandate needs to be a week later on the 18th of May. And I have not received any other NCOP programs in this regard, so those are the timelines. So we need to conclude our negotiating mandate so we get submitted to the Speaker for signature, and then to be tabled in the NCOP by Tuesday, or at latest, maybe say Friday or Monday.
Thank you, Johan. I recognize Honourable Smith. Honourable Smith.
Thank you, Chairperson. Chair, I just want to make a comment or one or two on the inputs that was made. I think there's even a view that local government is over legislated, if one can put it that way. I mean, it's been driven by a minefield of legislation. And the question comes to mind, will more legislation now suddenly solve our problems, or is it a matter of implementing the existing legislation that is there? And there's two things that is highlighted or that is being referred to in this conversation.
And I think one would want to see a more strengthening approach in this legislation when it comes to the responsibility that the MEC has over municipalities. And also, having said that, because you can just avoid so much should the provincial government of MEC has proper powers to respond adequately to challenges in municipalities, in particular in relation to this legislation that we are referring to this morning. Now, Chair, local government is a autonomy and is independent, correctly so. And that mere statement of fact tells me that it's only legislation and acts that can get local government to operate responsible and to be compliant. Now, I just wanted to understand, and I've missed some parts of the meeting because of my connection, Chair. To which extent does this legislation allow or accommodate your statutory bodies like your unions in municipalities, your salgas, and to in a sense be consulted with the appointment of senior management? And I'm saying consulted to the extent of perhaps having a say to say, look, we are objecting, or we are this and we are this. I know there's observer status currently in processes locally for unions and perhaps even Salga, but in what sense can this legislation be strengthening those bodies to have a more valuable contribution to these appointments? Thank you, Chair.
Thank you, Honourable Smith, for those observations. Any specific comments with regard to the amendments, Honourable Smith? Is that just
nothing specific, Chair. It was just about a more general approach towards yeah, thank you.
Noted, thank you. Honourable Maseko?
Thank you, Chair. I think you already asked the question. I was trying to take the notes for our negotiating mandate to hear, because member indicated the issue of he feels, if I'm right, he feels like there is the municipalities, the local government is too much legislated. And so I wanted to hear on the suggestion on that statement from him, or how should we go about to sort of tighten the screws where we see that there are loopholes. But just a comment from me, Chair, is always, when we have the bills or the acts that comes, and I always feel somehow that we have beautiful acts or the bills that we really goes through the legislative processes, but the part that always is lacking is the regulations attached to it, the rules, the like your code, the how part of it. And that falls on what our legal advisor, Mr. Masdorp, Advocate Masdorp, was saying, that there's no consequences if something is not happening that is supposed to happen. It's costly to the government, to the government pairs in things that should be happening. And usually on the local government, we know it's crazy season now. You'll see a lot happening, that you get a regional manager that has been there in the office in one municipality for years, but is a chairperson of the political party. And you watch it and you don't see anything happening, and there's no the consequences to that. And you ask yourself that now we are going to go through the process of negotiating mandate and all that, and there's no the direction of how are we going to make sure that that doesn't happen. It's like we are talking one and the same thing, that we sometimes will have to question our sanity, whether we are insane or we are sane in doing the legislations. When we say thumbs up with the legislation, but when it gets implemented, there's no the how part of it, for it to be a regulation that can empower the implementing agents to say how do they go about to make sure that the intended consequences there, or the intended idea is there within the municipality. So that's the frustration that I do have, Chair. And since you are my Chair, I have to just throw it all to you. Thank you, Chair.
Thank you, Honourable Maseko. Any other further contributions from members for clarity or questions or comments? If not, any of the presenters on the platform would like to respond to any of the observations and questions raised by members? I think Mr. McCann, thank you. There was a question raised by Mr. Mayepe regarding the WIP definition. Thank you. I recognize Mr. McCann and thereafter Mr. Mayepa.
Thank you, Chair. Just to respond on the comment that was made by Mr. Mayepa relating to whether we are conflating the definition of political office with political office bearer. No, we're not. There's a distinction. If you look at the Act and you look at the current definitions in the Municipal Systems Act, it makes reference to a political office bearer. So, but the current prevailing definition of political office bearer does not include a whip. Hence, our suggestion and comment that a whip be included in that definition, whilst we are also dealing with this bill. Chair, if I may as well, with your indulgence, just to comment on the consequences debate. There has been case law, reported case law, where courts have indicated and have held councillors accountable for decisions that were irrational and also unreasonable, and where they were personally liable for costs. So one may not necessarily always get the answer in legislation. However, one would get if it's, for example, the provision that Mr. Mayepa was talking about, which is clause 14. The councillor will be accountable in terms of the code of conduct, but also the councillor can also be held accountable if an application is brought to the court and a cost order is sought against that particular councillors that have voted in favour of an unlawful or illegal decision. Thank you, Chair.
Thank you, Mr. McCann. Mr. Mayepa, you still want to make a contribution?
Yes, thank you, Honourable Chairperson, members. Thank you, Mr. McCann, for clarifying that point. You know, with regard to the definition of the office bearer, the reason why I had raised it is specifically because I wanted to check its relevance, you know, whether we are using the phrase in the bill, you know, because remember, much as we understand, there are a lot of amendments that need to be introduced on the Municipal Systems Act, the Principal Act as it stands today. This was just the bill that we have is more a makeshift, as you indicated in your opening prelude. That we need this bill urgently to address the challenges, so that once councils have been have taken office, there needs to be a legislative framework that informs them on how they should appoint senior managers and stuff. I'm just worried that we should be careful not to take everything because there's a separate process to deal with other amendments within the Municipal Systems Act, so that we remain focused to the object of the bill, which is dealing with the appointment of municipal managers and managers directly accountable to them. Honorable Chairperson, the issue around the overregulation of local government, I know it's been set out there, all the time. But we also need to indicate here that from the problem statement that we shared with the members of the legislature, we are saying the Systems Act currently as it stands, read together with Section 182 of the Structures Act, do not provide the minimum requirements for appointment of municipal managers and managers reporting to them. And this legislation is informed, by Section 154 of the Constitution, is informed also, by Section 151 sub 3 of the Constitution. I wouldn't argue that no, there's overregulation. It's a necessary legislation to ensure professionalization of local government, to ensure that the caliber of people appointed by municipalities meet a particular set of criteria when they are appointed, to ensure that we support municipalities in building the capacity to perform their functions. I think I would leave it at that. I'm not sure about the issue that was raised by Honorable Maseko, that indeed we do have regulations, Honorable Chairperson, that gives more detail in terms of some of the areas that are covered in the bill, in terms of what procedures, advertisement of posts, short listing, long list, short list, constitution of panels, etc., which the MECs, have been, assigned the powers to ensure that they monitor that on a continuous basis as municipalities are filling senior manager positions. Like, with the exception of the issues, of course, that were raised by Advocate Masdog, as I've indicated earlier on, that he was quite spot on in terms of identifying some of the missing, provisions as to what happens to a particular MEC or minister if they failed to do certain things. But I also needed to caution Honorable Chairperson, members, that much as I agree, that there's no indication as to the consequence, of an MEC who has failed to honor his or her obligation in terms of the act. What should happen? I just wanted to, to bring this, to the attention of the members of the legislation, Honorable Councillor. The challenge currently is within our democratic system, we've got MECs who are appointed by premiers and not appointed by the ministers. So already it creates a problem in terms of accountability. And I'm just saying, whatever proposals, you will eventually agree at, you need to bear that in mind. I'm not saying, no, this is a can't do and et cetera, et cetera. I'm just saying, be mindful that if there was any person who needs to take an action for an MEC who fails to take a particular action, then we need to be clear in terms of the roles of the premier vis-a-vis the role of the minister. Thank you.
Well, so thank you, Mr. Maepa. I think that brings in a different dimension and level of manufactured complexity to the debate. So thank you so much. Colleagues, we need to decide now as to what we need to do now. Having heard the various role players and the legal advisors, we need to decide our next step, so to speak. And I think that my personal view, I think that the comments made by Advocate Maasdorp is particularly useful, and I think that we ought to incorporate some of it in our negotiating mandate. So my prayer would be that Advocate Maasdorp could possibly formulate or have the committee have a written sort of commentary on the provisions that we need to consider in terms of agreeing and finalizing our negotiating mandate. As for the comments made by the department, I think those are very useful comments, and I don't think that I have in particular any difficulty in terms of incorporating those comments too, since it's sort of in line with our legal advisors' interpretation of the amendments. We could certainly have that part of our negotiating mandate. So, colleagues, I want us to, decide on a way forward, and I have a few options that we need to consider. But before we do that, I would ask the officials, they are free to exit the meeting, before we consider our mandate, with a proviso that Mr. Advocate Maasdorp will draft his sort of comments and submit it to the procedural officer. I'll appreciate that very much. Honorable van der Westhuizen, see you have a raised hand.
Yes, thank you, Chair. Thank you, Chair. And before we allow the officials to depart, I think as a committee we need to first just take a stance on whether we, in general, support the amendment bill or not. And in that respect, I would like to propose and put it to the meeting that we, as a Western Cape Standing Committee on Local Government, in general support not only the principles of the bill, but also the clauses as they've been stated. But that we then, as a second phase or a second, then highlight a number of issues that we believe concerns us, and that should be brought under the attention of the NCOP. I am concerned about the strict timeline as set out by Mr. Kutsia, and he actually confirmed what I was fearing, that unfortunately time is not on our side and that we would not be able to go through different versions, if I could call it, of our mandate, and that ideally we should be finalizing our mandate to our NCOP colleagues or representatives today. And I was wondering if we could put it to Advocate Marsdorp to give us an indication of how long it will be for him, how long it will take him to quickly summarize the gist of his input, which, as you already indicated, we found to be valuable, and which one wouldn't like to get lost due to the time pressures, etc. So, and that's why I asked, but thank you also for indicating that other officials may take leave, but that we need to engage with Advocate Marsdorp a little bit more before we let go of him as well. So, Chair, my proposal first that we express our support in general, and then as a second phase that we then list a number of items or proposed amendments that we would like our NCOP colleagues to consider. Thank you.
Thank you, Honourable van der Westhuizen. Is there a seconder for that proposal? I think that I just want to amend it in a sense that that we support the bill with the proposed amendments that we will submit as part of our negotiating mandate. But should those amendments not be agreed to, that we still support the bill. Okay. Any differing sort of perspective? Okay. Honourable van der Westhuizen?
Yes, thank you, Chair. Can I just say, if I may, with all respect, I think for now we should not express ourselves on what if the NCOP, doesn't, accommodate some of our input. My impression, having dealt with a similar Section 76 bill just now, is that obviously we sent through our negotiating mandate, that they will then come back and report to us, whether some of our amendments have been incorporated. Obviously, inputs can be or will be received, I presume, from other provinces as well, and that we will consider in what we call our final mandate. So perhaps for now, I think we must just deal with what is in front of us and not preempt. Thank you.
Okay, no problem. With that, I with exception, and I think there was a request from Honourable van der Westhuizen to Advocate Marsdorp, is by when will he be able to draft his interpretation of the amendments that need to be effected, and having it forwarded to the committee for consideration. And Advocate Marsdorp can give us an indication. We appreciate that.
Chairperson, thank you very much. I will certainly liaise with my colleague Johan Kutsia in this regard as well. That's firstly. Secondly, I do recall, Chair, that the negotiating mandate proposed amendments, and I should certainly be guided here by my colleague Kutsia, proposed amendments may be in narrative form and not in the legislative drafting form. Now, that is crucial for me to know and to get confirmation of that, because if there's an expectation that I can do it in narrative form, then it certainly affects the timelines, because you will appreciate that to do it in legislative drafting form may require quite a bit of more onerous investment, if you like. So having said that, Chairperson, if you confirm that it need only be at this stage, at least in narrative form, then I can certainly provide a summary of my input earlier before close of business today.
Thank you, Advocate.
Unless the chair violently objects, then I can give it close of business next Tuesday.
I think, Jan, I see you want to make a contribution. I think narrative form, but you can just confirm that, Jan, would suffice.
Chairperson, no, that's correct. We can submit in a narrative format. I object to Mr. Marstorp's for next Tuesday, so let's work on close of business today. Chairperson, just to highlight, we do have a slot for tomorrow morning. So what we can do is, if I do get it in the course of today, we could submit the draft negotiating mandate report to the members, and then we tomorrow can get together for a 20-25-minute meeting just to adopt it.
Thank you, Anne. There you have it, Advocate Bowser. My narrative form is fine. And if we can have it by the close of business today, it will be extremely helpful. So, colleagues, official, Mr. Maepa, thank you for your attendance and your team. Mr. Kamal, for your attendance and your team, as well as Ms. Williams for your attendance, and equally so, Advocate Master, for your input and your attendance. I appreciate it very much. The committee appreciate it very much. You're welcome to exit the meeting, and so that we could, take care of other committee business now. Thank you.
Thanks so much, Chair.
Thank you.
Right, thank you, colleagues. Let's just conclude on this matter. Johan, in terms of...
I'm struggling to log out.
Okay, goodbye. So long, Mr. Maepa.
My computer is not responding, but I'm trying to log out.
That's all good, thank you.
Okay.
Yeah, I'm just reading a message here. Okay, look, collega's. Our negotiating mandate, the report from this committee will not be adopted today. We will get the input from Mr. Mastrop during the course of today for your consideration. We have the input of the department, and then on the basis of that, we will then briefly come together tomorrow morning at 9. It's probably be for half an hour at most, where we will consider the draft mandate or the negotiating mandate of this committee for the NCOP meeting, which is taking place on the 11th of May. Jan, is that sort of more or less the process?
Chairperson, that's correct. I just want clarity. The negotiating mandate report, will that include the proposals made by the department? So I can then start incorporating that into the negotiating mandate report. Then additional to that would be then what Advocate Marstorp then provide us with.
That's correct, yeah.
Thank you, Chair.
Thanks a lot. Right, colleagues, if that's in order with you, Andrikus, I recognize you.
Yes, thank you, Chair. Chair, so my expectation is that Mr. Kutsia will probably tonight, sorry for him, circulate to us a draft mandate in a format that we can tomorrow consider and hopefully adopt at our meeting. And that will be incorporating both Advocate Marstorp and the department's comments.
Yeah.
Correct, Chair.
Okay, thank you. So in terms of the clause by clause adoption, that will only happen before the final mandate stage, right, Jan?
Yeah, Chair, we just compile the final mandate. We don't specifically go clause by clause and adopt it. We will just say, look, they accepted X, Y, and Z from our negotiating mandate, and do we still support the bill? And then if the committee supports it, we provide. Otherwise, we reject it.
Okay, good. Thank you so much, Jan. Right, thank you. So, colleagues, tomorrow morning, 9 o'clock, we will reconvene to consider the negotiating mandate report. But before we exit, there are minutes that we would like to have the committee consider for adoption. And Jan, can you just flag the minutes, please?
Chair, I'll just try and make it a bit bigger here.
I appreciate that. Look at the minutes of the 17th of March. So page 1. Any amendments or additions? Page 2. Any amendments or additions? Can you scroll down, Jan? Thank you so much. Any proposal that we accept the minutes as is? Honourable van der Westhuizen proposed that we accept.
Correct. Thank you. I propose that this be accepted.
Johan, is there another set of minutes, eh?
Yes, Chair. I'm just want to look for him. It's that one.
Honourable Maseko seconded. The meeting we held on the 31st of March that gave rise to today's discussion. Page 1, any additions, corrections, or page 2, any corrections, additions, or emphasize. Great, thanks a lot. The meeting adjourned at 12:59. I see there's a proposal from Honourable van der Westhuizen that we accept.
Correct, Chair.
And seconded by Honourable Maseko.
Yes, Chair.
Thank you, ma'am. Okay, Jan, that brings us to the end of the meeting. Thank you, colleagues, members, Candace, Nomfundo, and everybody else that was involved with making this meeting today possible, and for your input, Tsepo, much appreciated, Tsepo. Honourable Smith, we will reconvene tomorrow morning at 9 to finalize the negotiating mandate. Jan will send out the meeting invitation and the agenda for today and a draft copy of the report for consideration. Members, thanks a lot. Have a wonderful day, and we'll see each other tomorrow morning. Thank you.